Aiboan, Vanakkam, Assalamu alaikum, and a very good evening. Welcome to this, the first in yet another innovative series of online resources from AmCham Sri Lanka, the Law Review 2021. The Law Review will take you through a series of contemporary legal topics of impact on your business and business continuity, helping you navigate the quagmire that can be legalities. This series of offerings is planned for the second Tuesday in each month, and we hope to see you join us on each and every one of them as we bring you contemporary and immediately impactful issues of importance to you. Today, emerging issues in labor laws in Sri Lanka. Let me hand you over to your host and moderator, Donna Padnavitadna. Donna, over to you.
Thank you, Rai. Thank you very much. For today's session, we have a very eminent panel of speakers for this really nice webinar on emerging issues of labor laws in Sri Lanka. So let me introduce each one of them to you. Let me start off with the President Counsel, Mr. Jeffrey Algaratnam. Mr. Jeffrey Algaratnam, President's Counsel and past Presidents of the Bar Association of Sri Lanka for 2015 to 2016 and 2016 to 2017 was admitted to the bar having passed his final examination at the Sri Lanka Law College with a first-class honours. He holds an honours degree in law from the Faculty of Law of the University of Colombo. He counts over 40 years in legal practice. He practices in the original and appellate courts of Sri Lanka, specializing in industrial, corporate banking, and intellectual property law, and engages in an advisory practice in industrial and commercial transactions, among others. He also practices before statutory authorities, bodies, and commercial arbitral tribunals. He has taken keen interest in areas of public law and is actively involved in public interest litigation and issues of constitutional and governance issues. Mr. Algaratnam possesses a management background, as well as having also followed a global leadership program conducted by INSEAD in collaboration with Institute of Chartered Accountants of Sri Lanka. He is a director in the Law and Society Trust and a member of the Center for the Study of Human Rights, University of Colombo, Faculty of Law, and also a member of the Faculty Board of the Faculty of Law. He is also an advisor to church organizations and schools on a range of legal issues. He has examined and lectured at the Faculty of Law of the University of Colombo and as a lecturer for the LLM program conducted by the University of Colombo. We warmly welcome you, Mr. Algaratnam. The next panelist would be the President Counsel, Mr. Udita Egalaheva. Mr. Udita Egalaheva counts over 30 years at the bar. He joined the Chambers of Attorney General of Sri Lanka in 1990 and served as counsel attached in the government institutions, a branch, a state council, and then as a state senate, a senior state counsel for a period of 15 years. Mr. Egalaheva joined the private bar in April 2005 and is presently a leading practitioner in public law, constitutional law, insurance law, commercial law, and employment law in the original courts as well as the superior courts of Sri Lanka. Mr. Egalaheva is an independent director in several public and private companies. He is also a commissioner of the Legal Aid Commission of Sri Lanka. Mr. Udita Egalaheva was confirmed Silk in 2012 by His Excellency, the President of the Democratic Socialist Republic of Sri Lanka. As a counsel, he has extensive litigation experience in both original and appellate courts. He has served as the sole arbitrator and also as a member of arbitration panels appointed to resolve commercial disputes, local and international. Mr. Egalaheva had his basic education at Sri Lanka Law College, followed by a Master's in Law, LLM, University of Colombo, and a second Master's degree as a World Bank-sponsored scholar from the International Maritime Law Institute of Malta, in which he graduated with distinction and was awarded the Professor Walter Muller Prize. He also holds a postgraduate diploma in insurance law from the University of Colombo. a senior visiting lecturer to several academic and professional organizations, and a visiting lecturer at the Institution of Commercial Law and Practice. In the area of arbitration law, Mr. Egalaheva has published over 30 academic publications and over 30 public presentations on topics relating to the law. We warmly welcome you, Mr. Egalaheva. Joining us, Attorney at Law, Mr. Sarveswaran, Senior Lecturer, Faculty of Law, University of Colombo. Mr. Sarveswaran is an attorney at law and a legal academic, currently employed as a senior lecturer in the Department of Private and Comparative Law, Faculty of Law, University of Colombo. He holds a Bachelor's of Law from the University of Colombo, a Master's in International Peace Studies from the University of Peace in Costa Rica, and a Master's of Philosophy in Labor Law from University of Colombo. Among his involvements, Mr. Sarveswaran was designated as the Director of Legal Research Unit during 2007 to 2009, and currently the Director of Labor Law Studies for Master of Laws program for Faculty of Law, University of Colombo. He was engaged in the expert committee to the drafting of a new constitution in 2020, and is a senior consultant of the UNDP Law Review Project at the Human Rights Commissions of Sri Lanka from 2002 to 2004. Well known for his vast knowledge with regard to the study of labor law, he also possesses a strong versatility in subject matters such as industrial law, environmental law, as well as peace and conflict studies. Apart from his position as a senior lecturer in Colombo Law Faculty, he is a visiting lecturer at many other state and private bodies. Depicting years of expertise and service rendered in the field, Mr. Sarveswaran was awarded the Asia Leadership Fellow of Japan and Environmental Law Champion of Asia, International Union for Conservation of Nature by the Asian Development Bank. His recent authored work include COVID-19 pandemic and emerging labor issues in Sri Lanka, an assessment of legal responses and COVID-19 pandemic and termination of employment, an appraisal of legal responses. We warmly welcome you, Mr. Sarveswaran.
Thank you.
All right, I'm going to give a brief introduction about the topic. Our topic today will be the emerging issues of labor law in Sri Lanka. As we all know, the COVID pandemic has receded, the markets, the economies to reopen, along with standing focus on efficiency and growth in the workplace will have to be given priority for any business model resilience. This is because we have seen how volatile the world is and can be. When it comes to the workforce and resilience, more specifically, companies have to balance the great dichotomy of employees seeking certainty with stability, with organizations themselves pursuing flexibility and agility. Consequently, we will need a sustainable reset of the workplace, not a short-term one. It will require a new culture and a strong legal framework. Hence, for an in-depth look at the emerging issues in labor law in Sri Lanka and the contemporary economic conditions, and insight on what business leaders can do and must do to navigate them is the focus in today's topic on the first AmCham Sri Lanka new series of legal webinars. All right, let us start. Okay, my first question I would like to ask from Mr. Sarveswaran, if that's fine. Okay, my first question, Mr. Sarveswaran, would be, sir, what are the emerging issues that is being identified in labor law as a result of the current pandemic that we are facing right now?
When it comes to the emerging issues, I would say we have emerging issues under each and every labor legislation. But because of the time factor, I would mention a few. One is the change of work arrangements. So when it comes to the different forms of work arrangements, the question will be whether the person who is engaged in the work is an employee or not. So different forms of work arrangement. The other one is reduction of wages. not deduction, but reduction of wages. That is another issue. The other one is unilateral decisions by the employers to make use of the statutory leave during the period of lockdown or when it comes to quarantine period and all. So the employers make unilateral decisions to make use of the statutory leave period. The other one is non-availability of paid sick leave in the labor legislation when it comes to the employees who contact COVID-19 from the workplaces. The other one is non-availability of quarantine leave in the labor legislation when it comes to the employees who contact COVID-19 in the workplaces. The other one is delays in statutory contributions like EPF, ETF, and gratuity, and also surcharges for the delays. So when it comes to the EPF Act and the ETF Act, of course, there are provisions to waive the surcharges, but when it comes to the gratuity act, there is no such provision which empowers the commissioner to waive the discharge. Other one is non-availability of provisions with regard to biological hazards. When it comes to health and safety, right, there are no provisions with regard to to ensure obligations of the employer or employers to ensure health and safety, mainly when it comes to biological hazards. Other one is when it comes to the pregnant mothers. So they are mostly affected. So when it comes to the maternity benefits ordinance or the Shop and Office Employees Act, so there are provisions, not to employ a pregnant woman during the 3 months period before the confinement in any work that may be injurious to her or to her baby. But the doubt is, whether the uncertainty is whether that covers biological hazards also, and also it should not be limited only to the 3 months period before the confinement, and also not only the female workers, even the pregnant mothers, even the all the workers who have serious health complications. Other one is the payment of compensation when they contact COVID-19. The workers contact COVID-19, whether under the workman compensation ordinance they are entitled to payment of compensation. So the other one is various types of disputes that arise because of terms and conditions of employment, unilateral variations, and also another issue is the terminations of employment because of COVID-19, closure, non-disciplinary terminations, closure. Other one is retrenchment, permanent non-employment, temporary non-employment. So we used to say layoff, and also there could be any other form of employment, but mainly these are the labor issues that have emerged because of COVID-19.
Thank you very much, Mr. Sarveshwaran. Thank you, sir. All right. I'm having trouble getting my video on. All right. The next question I would, one second. Okay. All right. Thank you very much. The next question would be, Mr. Sarveshwaran, what are the impacts, or are there any significant impacts on the employer-employee relationship due to these issues that we are facing at the moment?
Definitely, there is no doubt about that, because when it comes to the situation now, so we say the pandemic situation, right? So now at the beginning, maybe in the early part of 2020, we never expected that it will continue for a long period. Now, because of the impact of COVID-19, all are affected. The employers are affected, the employees are affected in so many ways. So when it comes to employer-employee relationship, right? So we always say that survival of one party depends on the survival of the other. So when it comes to the situation that we have now, so the employers are very much affected. So they have so many economic issues and all, and also they are unable to continue their business or retain their workers and all. At the same time, the employees are affected in so many ways. when it comes to termination of their employment. So in Sri Lanka, we don't have the social security schemes and all, other than the compensation formula and all the compensation under the labor laws, right? We don't have any other security schemes, the social security schemes which are available in other countries. But here, the employer will have to shoulder the burden of paying the compensation to the workman. But the state doesn't play any role in that regard, right? When it comes to many other countries, the state also will take part, and also they will have the social security schemes and all. Through that they will pay. But here in Sri Lanka, so the burden is on the employer. So in that way, the employers are also affected, right? So one is they can't continue their business. At the same time, when it comes to termination of employment, so we have very rigid provisions in the labor legislation. So they will have to pay compensation. And also when it comes to situations where they can't provide work, also it is not that easy to terminate their employment. So then at the same time, the employees are also affected. So it affects all. There's no doubt about that.
Yes, thank you, Mr. Sarveswaran. In that case, I'd like to ask, well, how has it affected to the employee in terms of working arrangements?
So working arrangements now, because of COVID-19, now we have gone for various forms of work arrangements, which we never thought of, right? But now when it comes to these different forms of work arrangements, even working from home, that is one arrangement. And also there could be many other arrangements using the modern technology. So sometimes the issues will be when it comes to the people who are engaged in such work arrangements, whether they are employees or independent contractors, because our labor legislation will apply if there's employer-employee relationship. So if there is employer-independent contractor relationship, then that will not come under the labor legislation. So that issue will arise. So that is why I would say that different forms of work arrangements, that will create that type of problem in future. And in future, I think we will go more and more work arrangements, maybe atypical arrangements. So there the issue will be identifying the employer-employee relationship when it comes to such arrangements.
In the same way, Mrs. Sarveswaran, if you speak about the reduction of wages that we are currently facing, how will it impact to the employer and the employee?
So when it comes to reduction of wages, we don't have any provision, as far as I know, in the labor legislation for reduction of wages. But we have provisions for deduction of wages. So when it comes to the Shop and Office Employees Act, Section 19 provides for deduction of wages. So when it comes to the Wages Boards Ordinance, Section 2 provides for deduction of wages, that also with the concern of the workman or the employee, and also only the authorized deductions. So when it comes to reduction of wages, the issue will be whether it will have any, because when the employers go for unilateral decisions, I would say it may not have the legal basis, because we don't have provisions for reduction of wages in the labor legislation. But I would say when it comes to Sri Lanka, so we have to think of an amendment to the existing legislation or a new legislation in the light of our experience of COVID-19. There we have to have provisions for reduction of wages also when it comes to such situations.
Thank you so much, Mr. Sarveswaran. Thank you, sir. All right. Next, I thought I will come back to you, Mr. Sarveswaran. There is one more that I would like to discuss with you, but let me come to Mr. Udita Egalaheva. Sir, many employees have opted off contracts because of the economic challenges resulted of a pandemic. Because of this layoff, retrenchment, loss of employment by closure of business is quite apparent at the moment. So how does the law deal with the non-disciplinary terminations in this private sector?
Yes, Dora. When it comes to non-disciplinary termination, we have to look at several categories of employees. there are a number of categories. Say, for instance, starting from the permanent employees in a workplace, there are casual employees, there are fixed-term employees, there are probationers. So when you take each of these categories, the law treats them differently. Now, as you know, we have a scheme introduced by the legislature in case of loss of employment or termination, non-disciplinary termination. That is termination of employment of Workmen Special Provisions Act. But there is also case law that is specifically, that is Browns and Company versus Commission of Labor, which has held that the probationer cannot apply under the termination of employment of Workmen Special Provisions Act, or in short, we call it TEVA Act. So the probationers basically have no recourse because even in the labor tribunal, unless there is mala fide, probationer's application may not be entertained. As far as the probationer is concerned, the employer's decision is considered to be the final decision, unless there is mala fide. So they are unable to apply to the Commission of Labor under the TEVA Act. Then on the other hand, I think during this pandemic, we saw that first to be terminated were these probationers, casual employees, and fixed-term contract employees. And all these categories have very little protection from law because the courts have held that a casual employee has no right for reinstatement, and also they remain to be casual employees and they have no hope of permanent employment, and so on. So therefore, only the permanent category of employees can recourse to the TEVA, that is Termination of Employment Special Provisions Act. Other than that, they also have the remedy of labor tribunal. Whether it's disciplinary termination or non-disciplinary termination, any applicant or workman can apply to labor tribunal. Of course, labor tribunal is not guided by any kind of formula. That is a just and equitable jurisdiction where the amount of compensation or a decision to be reinstated would be on the basis of just and equitable considerations. So therefore, to answer your question, for non-disciplinary terminations, either you can make an application to the Commission of Labor or to the Labor Tribunal. But I would say the most effective application would be, if you are eligible to apply, if there are more than 15 workmen in your workplace, that is to the Commission of Labor under the Termination of Employment Special Provisions Act.
Thank you very much, sir. Thank you, Mr. Galaheva. All right, this arises me with another question that I would like to ask from Mr. Alagaratnam. Mr. Alagaratnam? Sir, can you hear me?
Yes, I can.
All right. Okay. My first question to you would be, how can we view the Sri Lankan labor law with regard to unilateral decisions of employees to make use of statutory leaves, or let's say the availability or the non-availability of paid sick leave, or the availability or non-availability of paid quarantine leave, or the delay in the statutory contributions? How can you view the Sri Lankan labor law right now with regard to these?
Well, basically there is nothing specified in the law as such. Can you hear me? Yes.
Yes, I can hear you.
Okay. So then what I would say is that there is no express specific provision, but this is an unusual situation for which it would have been preferable if legislation was enacted speedily to cover certain situations, which has not been done. And I would think that in a situation like this, a pandemic, what is needed is the cooperation between employer and employee. Neither party should be permitted to exploit the situation to the disadvantage of the other. But there should be a certain amount of accommodation. That's my personal view on the matter. So to come to your questions, you're talking about unilateral decisions of the employee, where they are talking of the employee saying, no, we'll set it off against your leave, your absence. Okay? And I understand that's what you're suggesting during the period of the pandemic. And also using paid sick leave or whatever it is and exhausting the leave. Now,
Correct.
so I suppose there has to be some cooperation because there is a large period during which the employer also is badly affected, and so is the employee. So the question is, what is the compromise? And I would think that this type of mechanism is best handled by, in the absence of legislation, there should be the Commissioner of Labour, who is a person who can conciliate between the parties. And the Commissioner of Labour, if there's a dispute where there is, let's say, refusal to permit a person to avail of his sick leave or forcing a person to use his sick leave, or, for example, a unilateral decision of the employer to make use of the statutory leaves and cut off the leave during the period of the pandemic, those are matters that have to be really negotiated in the absence of specific legislation. And so it's a very open area. It's unusual. I would have preferred if there was legislation empowering certain things. We have to accept that this is a type of situation which is unforeseen by the law. And it has to be somehow or other covered by the law, which has not been done. And I would think that it is more a matter of negotiations, compromise on both parties to see how best this could be taken forward, because it's essential for both to cooperate in an unusual situation like this. I hope I've shed some light on your question.
Thank you very much, Sagarakam. Yes, definitely. You have shed a lot of light. All right. Mr. Igalaheva, sir, can I just, I would like to pose my next question to you in terms of compensation. And are there any compensation regimes that the employees are entitled for and above this situation?
Yes, Donna. As I told you, as I pointed out earlier, under the Termination of Employment of Workmen Special Provisions Act, there is a formula. And this formula was first, I think the existing gazette came in 2005. And of course, there was no revision since then for almost 15 years. And recently, the Cabinet of Ministers took a decision to increase the cap given in the formula, which is 1.25 million to 2.5 million rupees. I have no particular objection to the increase, but except that I would say the timing is wrong to increase the cap given in the formula, because this is a time where a lot of employers and employees are facing numerous issues due to the pandemic situation. Other than that, as I said, the other option to an employee is through the labor tribunal, most effective. And there is no formula. It is based on the facts and circumstances and just an equitable consideration. There are a lot of principles that govern when a president of a labor tribunal decides how much compensation or whether restatement or any other relief to be granted to an applicant. So these are the main two regimes available for an employee. Prior to even today, there is a provision for retrenchment under the Industrial Dispute Act for categories which are not covered by the termination of employment as Workmen's Special Provisions Act, but hardly used because most of the workforce is now covered by the TEVA. So as a result, these are the two regimes now operate for compensation. That is the TEVA Act formula and the Labour Tribunal. And so those are the two available options. And now the cap has been increased to 2.5, but the Gazette has not been released yet. The Gazette may come at any moment. But as of today, since there is no Gazette, although there is a cabinet decision, the cap is 1.25 million and subject to the formula. Is there anything you wish me to clarify on this compensation issue?
Yes, so I think, yeah, it's pretty clear. Maybe I'm sure attendees we have much more questions, specific questions. So I will come back to you through that. And thank you.
Okay.
I will come back to Mr. Alagaratnam. So, considering this emerging employment trends like working from home, job sharing, there are a lot of new schemes that are coming up in terms of working at the moment. What are the laws, or are there any laws and regulations to govern them?
At the moment, as far as I see it, there is no laws, and we have not been able to catch up the new emerging trends. Leave alone the pandemic. People working from home, how do they clock in? How do they clock out? We are told that you cannot work more than X number of hours a week, and the maximum amount of overtime is so much. But the question is, when you're sitting in the comfort of your home, or the discomfort maybe, and having to work from home, how do you clock in and clock out? How do you estimate the time put in? Technically, those are issues. And also time sharing, as you say, so that can I work for two different employers on, say, IT matters? So now, can I serve two employers? How do I get paid? How do they calculate the hours? Now, these are whole new issues that are arising, even from the point of, let's say, employment of young persons, whether there should be a relook at the laws. Employment on IT, employment working from home, what are your working hours? There's no legislation on this. So if there's no legislation, whether we can say because of an unusual situation that has arisen, the COVID pandemic, in the absence of legislation, isn't it a matter of pure contract between the parties? And whether an employer and employee can agree, okay, you're working from home, you don't have to travel to office, so there's less physical stress, though there might be more mental stress when you're working on a computer, right? So whether I pay you according to this amount of input, this number of hours on your computer, or when you log in and log off, right? And whether that should not be governed by the ordinary labor law, which envisages you going to an office, having your lunch at a certain time, checking out at a certain time. Therefore, you can work only X number of 8 hours a day, or maximum of 1.5 hours overtime. Well, those rules and those laws have no relevance to this situation. Right? So it's an entirely new area where we have to rethink. And I think it's not only the pandemic, we have to think of this globally and the new scenarios that are emerging generally and internationally. Whether, as I told you, whether you can have fixed hours and say only 45 hours a week, whether you can have a person working for more than one employer, right? And whether you can have even young people working, say, we say that people can't work. Now, let's say universities, can they work part-time employment? I can work, if I'm studying at the university, can I work just 3 hours a day for you and then expect a salary? So can you catch up a lot of new situations? for which there is no legislation. We hope they can bring about legislation. Other countries are attempting to do so. But for the moment, it would seem to be more governed by agreement between the parties. Because one cannot look at the old laws that were there to say it will catch up this. It doesn't. That's my view.
Thank you, sir. Ms. Agaratnam, this has always been there, this working from home. Do you think that we should have thought about these laws and regulations a little earlier? What's your personal opinion?
Yeah, personally, yes. Because you see, there are a lot of things we should have thought of earlier. Because, like, for example, you take women down, they say you can't have night work for women. We talk of gender equality. Of course, maybe in Sri Lanka, we have situations where, I don't know whether it's not safe for a lady to be walking on the road at 8:30 in the night or whatever it is as contrasted with the man. I don't know. But then why do we distinguish and say ladies should not be permitted to work except in limited situations after 8 in the night or 10 in the night? So, working hours of women. And those are things that I know, because you hear of various things like call centers, which work through the night 24 hours a day. And nowadays we know that the workforce consists of a lot of women. Right? And maybe sometimes the emerging trend is the majority of women in the workforce. So equal pay for equal work, that's another concept, which is women sometimes, the allegation is women get paid lesser than a man gets paid for the same job. Okay. Now, all those things have not been thought out. And of course, the Commissioner of Labour realizes that there are these anomalies, things that should have been done long ago. Unfortunately, Parliament is not up to it to pass the necessary laws or catch up these situations. So, Commissioner of Labour tries to relax these laws by administrative letters. But can the Commissioner permit letters, by letters, change the law of the land? It can be questioned, right? So, as usual, a lot of things should have been anticipated long ago, you don't have to wait till the COVID pandemic hits us. And it's high time we rethought all our labor legislation as to working hours, mode of working, flexi hours, night work for women, and split employment between two employers, or for example, university students being able to earn their upkeep during a university by working just only 3 hours or 4 hours a day where acceptable. Let's say whether it's in a supermarket or in a training center or something like that, because everybody does it all over the world. On campus, you go work in a refectory, you have a free meal, you get an allowance, you're paying for your, but here you can't do that. So those are things that have to be considered. And then whether those people who work, say just 2 hours, 3 hours, whether you need to pay EPF for them, EPFs for some sort of saving. If the guys gets sick, they have some source of savings to put by, because a lot of the people mainly cannot burden their parents when they're even students. So isn't there opportunities for them? And shouldn't they be protected? So there are a whole range of ideas in labor law which have emerged long ago, for which we have lagged behind, and for which there has to be a rethinking. I hope I've sufficiently covered what you, of course.
Yes, sir. Well, this just gave me another sort of line as to, I would like to actually pose this to all three of you, sir. Whom do you think is most disadvantaged when it comes to employees? Which sector or which category do you think, from a judiciary point of view or legal stand, under this current pandemic? First of all, I'd like to ask from Mr. Agaratnam, sir.
As Mr. Iglevla was saying, the people who are most affected are the casual workers, the probationers. So those people, because those people are vulnerable, the protection of the law is minimal or nothing for them. So those people are first to go. And also, perhaps even the women workers might be also prejudiced, because in our society, which still tends to be a little bit more male-oriented, sometimes women can be prejudiced, and especially things like factories closing down. Majority of the people are women who are working there. So a factory might have a legitimate grounds to say, look, We have no orders. Nobody is buying clothes abroad with the pandemic. Everybody has cut down we have no orders. Everybody has cut down their purchase of fashionable clothes. So what can I do? So the garment factory workers, who are mainly females, casual employees, probationers, as Udita was mentioning a short while ago, those are the people who are most vulnerable because you earn by the day. If I can't give you work, you don't have anything. Whereas if you're a permanent employee, perhaps you can negotiate with your employer to say, okay, I'll take a pay cut for the next 6 months. We'll review it after that. And I scale down my level of expenditure and living. But these other workers are perhaps, in my opinion, more vulnerable than the rest. Everybody is vulnerable, but they're able to maintain a certain amount of stability or a bargaining strength when you're a permanent employee. Otherwise, even if you're a permanent employee in a factory, a female worker might have a lot of problems because they have no orders. And what happens? So those are my views as to who can be most vulnerable.
Thank you. So, Mr. Egalaheva,
Yes.
anything to add?
I think Jeff has summarized the entire the answer, but I would say if you look at the sector-wise, there are certain sectors which have been badly affected, especially the tourism, the airlines, and the garments, of course, to a great extent. So these are the sectors that have been now. The tourism, of course, is almost dead, like zero. There is no business, there is no employment. Almost 90% they have lost their business. And similarly, the airline employees have been retrenched worldwide, I would say. And the garment factories, and I know there are several number of factories for loss of orders. They have retrenched, or rather, they have, sometimes without recourse into any legal avenues, they have just said we have no work to offer. So the legal, I would say the legal, the answer would be that in such a situation, it would be very difficult even for a workman to challenge, because there is no termination, there is no work to be offered. So obviously the employer might take up the position that this is a frustration situation, because due to no fault of the employer or the employee, they have lost an employment. They lost their jobs. So as a result, I would say we need certain statutory protections, because even the employers underwent serious cash flow issues. Now, when there are serious cash flow issues, even the little bit of employers who have say little business during this time, especially the export business, they had delayed payments, delayed shipments, delayed payments. So as a result, there were cash flow issues. But we have no provision to delay a statutory payment, taxes due to the government, EPF, ETF payments. There are no statutory provisions to avoid a penalty. But if one looks at the provisions of Singapore, in Singapore, there is a temporary provision act they have enacted, that is Act number 14 of 2020, which is operative for only 1 year. And that piece of legislation deals with every minute thing. And that piece of legislation, which is operative for only 1 year, has 157 pages. You can imagine to what extent they have dealt with in every possible area. So we don't have anything. As we discussed earlier, there are a lot of employees who are very vulnerable to this situation. Equally, there are employers who are vulnerable to this situation. They have lost their business. And where the Labour Department has insisted on payment of compensation, despite the threat of the entire workplace getting closed. So there are several issues which the legislature should have addressed, but we have failed to do so.
Thank you, sir. Mr. Sarveswaran, sir, would you like to add anything on this?
So I think actually when it comes to the question, I think Mr. Jeffrey Alagaratnam and also Mr. Igalagava has both have given the answer. So, but only thing I would say when it comes to all these labor issues, but now because there are no provisions in the labor legislation to deal with all these things, but the best option would be conciliation, as Mr. Jeffrey Alagaratnam has already mentioned, right? Conciliation is a mechanism under the Industrial Disputes Act for settlement of industrial disputes. Recently, there's a judgment from the Supreme Court also. So there the Supreme Court has decided that if the dispute has been settled by conciliation, in terms of Section 12(1) of the Industrial Disputes Act, then the matter cannot be taken up in a labor tribunal, right? The same matter. So because I would say that I would say that may be the only judgment we have when it comes to conciliation, the judicial recognition of the settlement by conciliation. But I would say we can draw an analogy and apply this to various other situations also. So the best option to the parties and to the commissioner is settlement by conciliation under the Industrial Disputes Act.
Thank you, sir. I just want to clarify, how does this affect to people with disability for their employment?
Sorry,
how about the people who have disability?
Mm-hmm.
Due to this pandemic, do you think they are also in a very, very difficult position to continue employment?
Employees who have differently able people?
That's right.
So then, I think when it comes to the labor laws, there are no specific provisions with regard to the people who have disabilities, but there is a legislation. That's a very general one with regard to disability and all, right? But when it comes to the labor legislation, we don't have any specific provision. But when it comes to the labor legislation, if there is any discrimination at the time of recruitment, so we don't have any legal remedy when it comes to the private sector. So Mr. Jeffrey Alagaratnam has mentioned many issues relating to female workers and also the different forms of discriminations. So I would say when it comes to discrimination, even based on disability also in the private sector, right, the problem will be, how to deal with that. But we have a legislation, but that is not a labor legislation. But when it comes to the employments, definitely the differently able people or the people with disability also will be more and more vulnerable, like the casual employees and the probationers and other types of employees. And also not only the disabled people, even the the elders also may be, because now in many places they are introducing the new forms of employments. So when it comes to the elderly people or the senior citizens, they may be unable to work in the new normal conditions. So using the technology and all. So they also become vulnerable.
Thank you so much, sir. My next question that I would like to impose on is Mr. Jeffrey Alagaratnam, sir. Sir, what are the new statutory laws and regulations that are existent at the moment to relieve employees?
When you say relieve employees, to let them go, in the sense that to terminate the employment, I don't see any new news. As Mr. Egaleva mentioned to you, there is the Termination Act. That is for non-disciplinary termination, where you say that you can't, you want to terminate because you don't have business or whatever it is, or you have to scale down your operations. There's also the redundancy provisions under the Industrial Disputes Act. I don't see, as Mr. Egelheva and Mr. Sarvesan were mentioning, I don't see any new statutes that have come in related to relieving a person. Of course, if a person resigns and goes, or if you have a golden handshake or you're able to amicably allow a person to resign and go after giving him some money, that is entirely a contractual matter and he goes. That's by mutual consent. But for you to terminate a person, you want to relieve him and let him go, there is nothing new as such. But of course, I would like to add this, that as Mr. Egelheva and Mr. Sarvesan mentioned, there is a new situation that has arisen. This is what you call a frustrating circumstance, where you have come to zero through no fault of yours. People should not abuse it. But in a situation like that, where the employer has taken a big hit, he has no work, or he's almost at a point of closure because of the absence of orders or work, then the question is whether, if the doctrine of frustration kicks in, whether the contract of employment itself also gets frustrated automatically. If the whole business collapses, everything with it collapses. Right? So technically, an employer might be able to argue that it's not a question of my letting my employee go. The law has killed me and killed all the employment contracts in the process. But one would hope that good sense will prevail, where both the employer and employee can sit together and say, okay, notwithstanding the collapse, the crash, is there some way forward where we can restart our relationship in a few months' time, or look at a temporary moratorium where we pay less or whatever it is? Those are adjustments. But I can't see any specific law at the moment, or a new law which permits you, like Mr. Egelheva said, the Singapore law has catered to all types of situations. We could have perhaps enacted laws to cater to this sort of situation, which we have not done. So in the absence of any new laws, we'll have to unfortunately rely on the existing laws, or we'll have to have a situation where we accept that the laws don't apply as such. It is now a matter of mutual negotiation because everything has virtually collapsed due to frustration.
Donna, your microphone is on.
Microphone,
Okay.
yeah.
All right. Thank you. Thank you, sir.
Yeah.
I would now like to come into the question and answer session, because I'm sure there would be many questions that would, open up areas for discussion, and will actually answer some of the very fundamental questions that could be missing out at the moment. So I'd like to go into the question and answer session. All right. There is one question from an anonymous attendee. Many IT companies in Sri Lanka employs foreign workers, example from India. What is the legal implication on this? How about EPF, ETF, and other statutory contributions?
Yes, can I answer? Yes.
Yes, sir.
Yeah, I think as far as the statutory payments are concerned, there is no difference. Whether you are a foreigner or a local, if you are employed in Sri Lanka, the laws in Sri Lanka would apply, and they have to be paid EPF, ETF, and all statutory dues, and they have the protection of all statutory provisions we have to any other ordinary person.
All right, thank you very much, sir. Yes, so before I go to the next question, I'd like to welcome all of you, all the attendees. If you do have any question, just pop in the Q&A chat, that icon you can see on the screen, bottom down, and I can pose it to the panelists. Yeah, I can see. Okay, all right, I'm getting it. All right. There's another one. When there is a curfew imposed by law, can employers set the curfew dates against the employee's leave? What can we say about that, sir?
Well, technically, they can't, because the leave has to be by a mutual arrangement. Normally, that is the agreement. Even if I have to take my annual, except for perhaps casual leave or medical leave. Casual leave is something I can just apply for one day at a time. Medical leave is I'm unwell. But if you talk of my annual leave, usually you have to ensure that there's a smooth operation of the company. So the normal concept is a person has to utilize his annual leave because it's essential for his physical well-being, but it has to be in consultation with the company so that he does not upset the operations of the company. But as I said, so technically an employer cannot say, okay, I'm setting off your the period of absence against your annual leave. Technically, that is, that's not how annual leave operates. But there can be a situation where the employer calls upon the employee to cooperate and say, now we have been without work for so many days, so we'll have to forego your annual leave to assist the company. Otherwise, for us to pick up again, if you're going to be taking annual leave, then our operations are going to be further jeopardized. So if it's by mutual arrangement and where the employee accepts it, that's perfectly all right. But unilaterally imposing it technically is not correct.
Thank you, sir. All right. I believe we have answered some of the questions that has been posed.
Donna, a few of the questions seem to have been posted in the chat box rather than in the Q&A box. So maybe if you can check in there. There's also a couple of questions coming up on Facebook. So you go ahead and take what's come up on the chat box, and then I will step in with the Facebook questions.
Sure. All right. Thanks, Ryan. All right. I'm getting a question. I'm going to post a question from Kalum Disanayaka. I'm working for a multinational company. They pay salaries even in statutory leave. Only European employees got leave with salaries. UK government has set provisions for the companies. Do we have such arrangements in Sri Lankan companies? I think it's been answered, but yet again, if there is anything more to add.
I don't think, I think there is nothing to be added because there are no specific provisions here in Sri Lanka. So the normal labor laws apply.
That's right. Thank you, sir.
Let me just step in with the question from Facebook while you grab those questions over from the chat box. Gayan Nanyakara asks, I have a challenge with new concepts like PEO. I can't hire expats as much as we want for a local company if required. I'm facing this challenge in my company. Are there any solutions available to me?
I don't think the question is very clear. I wonder whether he wants to hire an expat for his work or what?
I believe so. I think what I'm getting from that is that I think there are some sort of restrictions on hiring of expats, and this is posing problems to his company. So he wants to know if there are any.
It's just for him to. Go ahead, Ujita.
There are restrictions, visa restrictions, and so on for expats for work purposes. That is, you have to establish that skill cannot be found in Sri Lanka. So there are certain restrictions. Subject to that, you can. But of course, during pandemic times, of course, that foreign travel has been now severely restricted. So maybe due to that, you are unable to. But of course, as a country, I believe we should have our expertise and we must develop the skills. But where it is extremely difficult, there can be permission can be obtained.
Thank you, gentlemen. Gayan, there you go. There's your answer. Donna, over to you again. I believe there's a couple of other questions in the chat box as well as on the Q&A box now. So we're also kind of at the top of the hour. So let's jump in with them and then conclude after these 4 questions. Over to you.
Sure. Thank you. Thank you, Rai. I think this is a very interesting question. Can the employer ask the employee to work overtime without payment in the pandemic situation? That's by Indumati Sasi Mahendran. What are your thoughts, Saz?
Well, as long as it doesn't, my personal view is as long as it doesn't kill the employee, fatigue him and physically kill him, there has to be certain adjustments. And the law of the land, of course, envisages a normal situation where you say, okay, so many hours and so many hours overtime. So if there is urgent need to catch up because you have lost time, productive time, and I'm keeping you employed because some people are taking pay cuts. So instead of a pay cut, if I say, okay, I'll give you your same salary, but can we have an extra number of hours without you having to claim overtime, because that's going to send me under. So that type of negotiation and agreement between employer and employee, in my view, should be possible, because this is an unanticipated situation. The law normally anticipates a normal situation where you cannot compel overtime or request overtime over a certain number of hours, and also you have to pay overtime. But here, the law doesn't catch up this type of situation. So I would think that provided there is no physical harm to the employee, because if you can take a half a month salary pay cut for the next 6 months, where your employer tells you, no, I'll pay you a full salary, but can you give me X number of hours overtime, because that's the only way I'll catch up for the losses. So isn't that possible? I would think that talking sensibly, it should be possible.
Fair enough.
I agree with Mr. Jeffrey Alagaratnam, but there are situations where some employees complain because of the work arrangement, working from home and all. Sometimes they say that they have to work more hours without any payment. So some employees say, because earlier we didn't have that trouble because we went there and worked, and then once we left the workplace, that was the end of the day. But now, so we work more hours without any overtime payment, and also there are allegations like that also. There are cases like that also.
True. All right. I hope, Indumati, we have answered your question, which is a very positive one, but also it could be negative to the people employed. There is one question from ARM Sufi. What mechanisms are available to protect the labor rights of Sri Lankan migrant workers?
To my knowledge, there are no specific legislation to protect the migrant workers specifically. But of course, the normal protection would apply. I would say every employee has the protection of the law. And of course, sometimes the complaint of the entrepreneur is that there are too much of protection for the employee. But anyway, there is, I would say, sufficient protection for the employee. And now the complaint is that even due to this pandemic situation, there is no relaxation of it.
Yes. There's another one. How the local law applied for engaging people for remotely working from other countries? Are there any laws applied at the moment? This is one of the...
Donna, I believe the question also is sort of related to the same thing, so maybe we can couple that as well. I believe it's the same gentleman who has asked the question.
Yeah, that's right. Yes. All right, I'm just trying to, okay. Okay, there is a question, this could probably cover up couple up with that as well. We have a few employees working remotely from India and they don't have Sri Lankan work visa. What is the compliance we need to follow in employing these people to work remotely from India? What is the compliance point of view, sirs?
Well, guys, sorry, Jeff, go on.
Go with it. Go ahead.
Yeah, sorry. No, there is an interesting development in New South Wales, in Australia, New South Wales, that working from home, whether you are in fact considered to be a workman working in your workplace. In other words, whether you are entitled for workman compensation if there is an accident at home while you are working from home. There is this New South Wales case and also there is Uber case in UK. Both these cases held that although you are working from home, you are considered to be an employee and working in the workplace, and if there is any accident, you are entitled for workman's compensation. So if you apply the same principle to an employee who is working from India, whether India or Sri Lanka at home, he really works for you in a workplace here. So it's a very open thing, a debatable issue where there is no specific legal provision. But with the development in the law, there is always the possibility that court might hold that you are liable for all other benefits because that person, although working from India, is supposed to be working at your workplace in Sri Lanka. If you apply the same principle, but of course there are no statutory or otherwise any legal provisions covering that situation.
Of course, I agree with Udita on this point, that what Udita was trying to say about it deemed to be in the home. But there would also be a controversy where a person working in India, depending on the contract, if he has accepted the contract in India, whether that contract is based in India, where he is working, and should be governed by the Indian law and not by the Sri Lankan law. So that though he is working for me, and as you say, virtually he's in Sri Lanka on the IT platform, is the guy's contract really one that was finalized in India and he's substantial in India and he can't look for the laws of Sri Lanka to protect him? Perhaps he can try to look for the laws of India to protect him. That might be another aspect.
I agree with Jeff because it all depends on the facts and circumstances. That's what I said. Looking at the New South Wales and the Uber case, you can develop an argument, but there are no specific laws or provisions. So it depends much on the circumstances. I agree with Jeff.
I would like to add one other point to the point that Mr. Jeffrey Alagrata has mentioned. There could be another issue that when it comes to the Immigration Act, it says if a foreigner works in Sri Lanka, the person should have the visa, the visa should permit the person to work in Sri Lanka. So here what happens is the person is working from another country without any visa. So then that will be another issue that, when it comes to immigration and the Immigration Act, the person is not physically in Sri Lanka, but from another country, he is working in Sri Lanka and, without any visa to work in Sri Lanka.
All right. Thank you very much for your insights, sirs. And I think it's time to round up our webinar. And it's been a pleasure talking to you all and discussing all these issues, what we have at hand. And thank you all the attendees. Well, and I thank all the attendees for coming up for this session, and I request that there will be a lot of series. I'm sorry. So we have now come to the end of this informative and brainstorming session of the first AmCham legal webinar series. We believe that the topic today, emerging issues of labor law in Sri Lanka, was a comprehensive and contemporary one under the prevailing local and global conditions. Some of the key takeaways are that there are legislations that are unforeseen, that has not been taken care of at the moment, but it is right time that we should take note of, and to whoever the authorities are. And there are no laws to govern new employment trends, and these are some of the key things that should be looked. So I thank all of you again, and I thank all the panelists for your valuable time, and again to the attendees for coming up for this webinar series. And while thanking to all these honorable guests and attendees as well, I'd like to hand it over to you, Rai, to conclude. Thank you very much.
Thank you, Donna. Well, that brings us to the conclusion of an interesting an expose, as it were, I think, on the emerging issues in labor law in Sri Lanka, what can be done, what must be done, and what should have been done a long time ago, especially given the current business and, of course, social environment as well, which we need to take heed of. So on behalf of AmCham Sri Lanka, my sincere thanks to our eminent panel of speakers for sharing the knowledge and expertise with the AmCham SL membership, and of course, all our viewers this evening. Next session, we'll be taking a look at arbitration and the related developments, and of course, once more, we'll be featuring a similar star panel of speakers. So keep an eye out on our social pages and do join us on the next AmCham Sri Lanka Law Review. From myself, our panelists, and the AmCham Sri Lanka, stay safe, good night, and God bless you all.